To Senator Graham, the Judicature Appellate Jurisdiction Act came to mind. And in relation to criminal appeals, there is a provision there, it's popularly called the proviso, which says that in the substance of it is that in circumstances where the court thinks that the point raised in the appeal might be decided in favor of the appellant, the court can nevertheless dismiss the appeal if they consider that no substantial miscarriage of justice has actually occurred. And I'd be curious if Senator Graham's thinking is something along those lines, or if it's something in addition to that, or not that at all.
Madam Chair, I think we are forgetting that we are dealing with children. And I understand, remember, we have had the practical experience of that, of a teacher being returned to the classroom because of procedural breaches. But then we have a clause that says the best interest of the child. And I would want us to consider that in our amendments, whatever the procedural breaches, we must give consideration to the best interest of the child. So it cannot be that, for example, the person is found guilty of interfering with children, but there was a some procedural errors, and then the person returned to the classroom. We must, of necessity, consider the best interest of the child when the decision is being made.
And that would fix what exists right now. That would be an improved situation over what exists right now. Yeah.
Chair,
who has their hand up?
Sorry.
All right. In terms of the order, Member Rodriguez and then Member Green.
Oh, several.
Madam Chair, just so I understand and support what Senator Graham is saying, because, and what the speaker a while ago just said, we have to protect our children, and sometimes there are procedural breaches. What I would love to know from the legal team is, where would we put that protective clause in the bill? Where would be the best place? Because it is definitely something that we have to consider.
Madam Chair,
well, that is considered. Go ahead.
I don't think the
legal counsel.
Determining where to put it can be done after we have decided whether we can. So I think the legal team has to consider this point and determine whether it can be done. If we decide that it can be done, finding a place in the bill can be sorted out thereafter.
I agree. Thank you. All right. I think Member Green has his hand up.
Yeah, Chair, just to support Member Graham's point, I definitely believe that this should be included. We can find the right terminology. I like the direction that Council Foreman from the AG's chambers headed in relation to once there has been no significant miscarriage of justice. I clearly would have to phrase it appropriately. But I think the principle of ensuring that where there is overwhelming evidence of wrong being committed, and Member Graham used one of the offenses, but you can think of much more serious child-related offenses that we wouldn't want people to be able to, because of a procedural breach, to be back in the classroom. So I'm sure we can find appropriate terminology, but just to say I support the principle of it.
Absolutely. Thank you, Member Green. Let me not say. All right. So I think.
Ms. Wilkins has her hand up, Chair.
Pardon me? Member
I
Green, you
had my
still have.
hand up
Okay, sorry.
here.
Please go ahead. Please go
I
ahead.
wanted to just respond to what Dr. Gordon said and to remind everybody that if an act allegedly committed by a teacher crosses over into something which would be so disadvantageous to a child, then we may be looking more at a criminal matter. And we should be thinking of it differently. I don't think we should be thinking of it then as something that would rely solely or be solely within the purview of the council anymore. Sounds to me it's as if that teacher should be dealt with in a different way. So consideration of return to the classroom could only come after they have been released by the court.
Yeah, so please see the attached list, then say, as agreed, steps will be taken by.
Sir, Minister Green, you may need to mute.
Thank you.
Sorry. Minister Green, you wanted to say something? Or Member Green?
No, Chair, that's fine.
All right. Okay. All right. Go ahead. Okay, Member.
Just to add, Chair, that I fully appreciate what was said by Ms. Wilkins. My apologies. But we have to also contemplate that not every complaint or allegation may rise to the level of criminality. And if we go that route, we will create a gap, a lacuna. So we have to be careful about that as well.
Agreed, based on some of the cases I've seen that go to appeal and quashed, as Member Braham would say. All right, so we will again wait for our legal counsel, our legal team to do some reflection on those, and we come back at the next meeting. All right, section 60, there are no comments. Are we finished with 59? No, I think for section 59, we do have a observation concern query from JTA. 59. Right.
You're at 59, Chair.
So we just have an observation, one comment query that in relation to section 59.2, disqualifying offense as defined in section 2 of the bill means an offense for which penalty is a term of imprisonment of 2 years or more, causing death by dangerous driving, and forgotten baby syndrome, where a parent or guardian negligently leaves a child in a motor vehicle, would therefore amount to such an offense. But if the person is granted bail, which are the effects on the quality of his/her teaching for such an offense, when just juxtaposed with an offense of sexual grooming, not sure I understand all that, can't this person be reassigned to a position which still contributes to improving the education sector, example, lesson planning? And the response from the legal team was that this was an operational matter. But I think it goes into the discussion that we've been having, right?
Yes, because sexual grooming is a criminal offense. So I don't think it would be.
Maybe the legal team can help with the understanding of this query from the JTA. Members, any observations?
Chair, I don't know what to do with this one, to be honest. I mean, maybe I need to try, go back and see what really the JTA is trying to say. Maybe we can come back to this one.
Maybe the minutes of that date may give some other expansion to their thought.
Yes, agreed.
I think the matrix tried to capture, summarize as briefly as possible what they are saying, but I can't respond to it.
So we'll ask you to look in the minutes, or when the date when they came to do the presentation, to see if we can get a better explanation for what it is that they were presenting here. All right. There was no submission for clause 60. For clause 61, there was a recommendation from JTA where it said both sections 49.3 and 61.4 deal with revocation. However, the former stipulates that the individual has 7 days to surrender the license, where the latter states that the individual has 14 days. There needs to be consistency, as there are consequences for being non-compliant. And the response from the legal team is that the bill is to be amended at 49.3 to indicate 7 days. For clause 61, effect of revocation of registration, license, or authorization to teach, from the JTA again, the recommendation was that in relation to section 61.2, it is not clear whether the appeal in that subsection is in reference to an appeal of the disqualifying offense, for example, the Supreme Court or a higher court, or an appeal before the tribunal created under the bill. And the response from the legal team is that the bill is to be amended to insert to the tribunal at the end of 61.2.
Sure. So where a Supreme Court deliberates and there is either a conviction or acquittal, in this instance a conviction, the individual would not be able to appeal under this legislation. So I'm not sure what is being asked here, because I think the appeal would be given that it must be in relation to the legislation and not an external decision that is made by a competent jurisdiction. The appeals process for a Supreme Court decision is a separate process. I don't know if that's what they're trying to ask, because you can't appeal a Supreme Court decision under this legislation.
In the context of 61.2, 61.2 is speaking to an appeal before a tribunal, which is a continuation of the process. So it would be clear that that suspension would continue. I don't see, I wouldn't want to confuse it with any other jurisdiction.
Yeah, or any other process.
Or any other process.
I think they want to be clear that we indicate that it's appeal to the tribunal. So we have agreed with the proposal to include to the tribunal at the end of that sentence.
Resolve the issue?
Yes. I would think so.
All right, thank you. There are no submissions for Clause 62. For Clause 63, again, the Jamaica Teachers Association, consider whether the reporting is to be extended and not limited to Clause 50. Not sure. This is about the employer's duty to report dismissal or resignation of licensed teacher or instructor. And is this response coming from the legal team? For Clause 63? This is a response from the legal team? It's a response from the legal team.
Yes, Minister.
All right. All right. For Clause 64, there are no submissions. Clause 65, establishment of appeal tribunal, no submission there. Clause 66, appeals to tribunal, none. Clause 67, procedures to apply in relation to hearing of a tribunal. Recommendation from the JTA, Section 67(1)A, states that the notice of the time and place at which the hearing is to be held shall be served on the parties in relation to the complaint, and the notice shall not be less than 10 days. And this should read parties to the appeal and not complaint. And the response from the legal team is the bill is to be amended to delete complaint and insert appeal at 67(1)A. There's no submission for Clause 68 and 69 or 70. 71, there's a recommendation in relation to 71. Reasonable time limits for review should be set to ensure accountability. From the legal team, it says the bill is to be amended to indicate further period of 42 days, and the rationale, you see the rationale. I'm assuming this rationale is from the legal team? No, that's from the JTA? I'm sorry, University of the West Indies. All right. All right. Huh? All right, so I'm going to need acceptance from the committees.
No, sorry.
From the committee for these clauses. Go ahead, Mr. Foreman.
No, thank you, Chair. In relation to Clause 71, just want clarification on exactly the nature of the proposed change. The proposal, it says bill to be amended to indicate further period of 42 days. Is the intention to replace the language or such longer period as a tribunal may reasonably require, and substitute that with the fixed period of 42 days, so that the tribunal no longer has a discretion but has to make its decision within a 42-day window?
If that is, I wouldn't agree with that change. I understand that it can be abused the way it is now, but I think it is better to give the tribunal the flexibility and hope that they'll be disciplined and well. When you put 42 days and some exigency and the matter then ends, I think it should remain exactly as is, unfortunately. That's my view.
Chairman, it's not all the times that I agree with Senator Braham, but on this occasion I do. There ought to be an authority of flexibility in trying in a tribunal to go beyond the prescribed period, because what you really want is to allow the tribunal the opportunity to go through the case thoroughly and make the best award or judgment. And that flexibility ought to be allowed. What happens in a situation if the tribunal would have had this influx of cases to deal with? Yeah? And so you want to force the tribunal to make an award within a confined period and make a hasty decision. So tribunals are normally given that flexibility, and I'm not supporting this fixed date.
I concur with my colleague.
All right, so members, just to recap here from 61, we need the committee, we need the Joint Select Committee to accept, confirm, Clause 60, Clause 61, all the way through to Clause 71. Members? We need
Madam Chair, I'm not
confirmation
getting,
for Clause 60 to 71.
I'm not getting acceptance with 71. And I agree with what my colleague stated earlier, that to extend it to 42 days will basically box the tribunal now in a corner, and they want to thoroughly flesh out the matter without a timeline prescribed to it. I'm in full agreement with that.
Right, so we are accepting that recommendation.
Yes, Chair.
Right.
I'm in agreement as well with, what, 61 to, what was it? 60, 61, 71?
70, which one? This one we're talking about?
Up to 71. I'm in agreement with what we've discussed so far, yes.
All right, but not just 71. I'm seeking
Madam
confirmation for 61 through to 71, that the recommendation. Yes,
that's what I was, yes, confirming, Chair.
Yes. Save and accept the recommendation.
Senator, save and accept the 42 days. We don't accept the 42 days.
Right. Yes.
So save and accept that.
We accept what Member Bryan put forward.
And Senator Gale will second it.
Yeah.
Chair.
Yes.
Just to indicate, I don't think the 42 days was not a fixed period. It was to extend it from 28 to 42. And then keep the or such longer period as the tribunal may reasonably
That is what they were
require.
proposing? I don't think that's what they were proposing. You're sure you interpret it right?
We in looking at it, we cannot compare. They are saying that the court gives a time frame within which they will deliver their judgment. But what we're discussing is we're on 71, right? Right. So we are saying there may be a time when the court, even though the court gives a specific date, the court might indicate that
where
it's
is that?
not.
No,
rationale.
but where in a legislation is it stated that the court gives a date?
That's what
a judge may say something,
right, that's what
but
I'm
there is
saying.
nothing in law that prescribes it.
Right, that's what I'm saying. They cannot compare it. They cannot compare us saying or within a reasonable time to say that we must give a specific time frame within which to the tribunal is to give its decision, because the court is not bounded to not change that time that is given by the judge, because the judge may come and or you might hear that it's not going to be held. So it's not a proper comparison.
What you're saying is that the 42 days is being proposed by the technical team?
To extend it
and
from
not,
28.
Okay, I see. Chair, there's a new spin on the 42 days. We never understood it initially. So the technical team is saying that they're the ones proposing to replace or substitute 28 with 42. And then everything else would remain. And if that's the case, then I don't have a difficulty with that.
All right. All right. So, considering the time, we will pause. We'll pick up at our next meeting with all the carryover matters at the next meeting, and on the on part 10, the general component of it. So for the next, should I ask if there's any other business? Or the date of
so
the next,
Chair.
Hold on. No. Date of the next meeting is January 26th at 10 a.m. And then we have some dates in February, which would be the 2nd and the 16th. Okay. 26th. Mm-hmm. And then February 2nd and February 16th. What time? 10 a.m.
What time on
They're all
those
10
days?
a.m. All 10 a.m. All right. So Member Hamilton, February 2nd, 10 a.m., February 16th, 10 a.m. So, Member Hamilton, yes,
So
your
move,
time.
Chair.
Yes. All right. Thank you so much, members. Thank you.
Meet 6 young people doing great things to tackle poverty, inequality, exclusion, and crisis in Jamaica. They're part of teams leading game-changing solutions and valued partners in UNDP's Ready, Set, Great Youth Development Showcase 2020 and 2021. These are their stories.
Hi, I'm Lenicia Roden, founder and executive director of Young Women and Men of Purpose. Some of the main problems that young people face that we work with are that they do not get proper career guidance. So many young people do not know the career path that they want to pursue, and for those who know, we find that many of them have never had any guidance as to how to achieve the career path that they're interested in.
I'll go through pitching from the canvas.
They've never spoken with anyone in the field that they're interested in. They do not know the subjects that they need to choose to get there. Many of them face challenges getting employment after they have completed school. Some of them, they are interested in starting their own businesses, but again, they do not know how because they've never been introduced to entrepreneurship as a course. And so these are some of the key problems that we see them having. As an organization, we have a career mentoring program for young people between 13 and 25 years. They enroll in the program. We allow them to take the career quiz to figure out what career paths they can pursue based on the subject that they're interested in and also based on their skills, interest, and passion. Once they have done that, then we introduce them to the career, and we also pair them with different mentors, persons in the field that they're interested in, so that they can learn more about the program. Another key thing that the organization does is we have entrepreneurship programs where we provide entrepreneurship training and support to young people who are interested in becoming entrepreneurs. Not only do we provide the training or theoretical training, but we give them practical experience, connecting them to successful entrepreneurs in the field. We also try to ensure that we're equipping them with the necessary resources through seed funding to actually get them started. And we connect them with agencies and organizations that support entrepreneurs in Jamaica, such as the Companies Office, the Tax Administration, JIPO, and other agencies that support entrepreneurship. We are already doing work to help to reduce poverty through our career development program as well as our entrepreneurship programs. And the reason is that youth unemployment can be reduced if more young people know the career path that they want to pursue, and they know how to get in the different programs in universities. And so for us providing career guidance and mentorship for them, we actually increase the matriculation into tertiary institutions and connect these young people with job opportunities so that they can earn to take care of themselves and their families. Similarly, for those who want to go into entrepreneurship, there are many young people who cannot get jobs in the fields that they're interested in. Many of them have different skills, creative skills, and knowledge that they can use to start their own businesses. And so when we help them by providing training in entrepreneurship and also that resource or seed funding to get started, then it means that they are able to start their own businesses, sell their products and services, earn money to take care of themselves and their families. So by doing these two things, we are helping to reduce poverty in Jamaica. There are two call to actions that we're very passionate about. The first is strengthening and promoting entrepreneurship as a viable career option and including it in the curriculum across schools. The second is the expansion of business incubators for young entrepreneurs across the country and including services that will support youth entrepreneurship. We have worked with hundreds of youth entrepreneurs across Jamaica, providing entrepreneurship training, business mentoring, seed funding to help them to start and to grow their businesses. We have seen the changes that this has made in the lives of the entrepreneurs and that of their family. And we believe if you assist us and the UNDP in supporting youth entrepreneurs across Jamaica, it can change the landscape of the economy and reduce poverty.